Welcome to this free immigration help channel. Today I wanted to make a video specifically on Child Status Protection Act and what we call aging out. Specifically whenever it refers to family preference categories, immediate relative categories. So I've been getting quite a lot of questions from you guys. You know, on this channel I do by volume. I answer questions. I try to do it every day, try to make a video every day specifically concentrating on your questions. And recently I've been getting quite a lot of questions regarding aging out. So I decided to make this video to describe this in a little bit more detail, specifically who CSPA applies to, and how to calculate in some situations in which you can take advantage of the CSPA, which is a Child Status Protection Act. As always, all the information provided in this video, as it is always in all the videos on this channel, are directly from official government sources. In this case, we're going to be working with uscis.gov, which is the official government website for U.S. citizenship and immigration services. And this particular link I will put in the description of this video so that you can do your own research. And as you can see, the last update on this particular topic on this particular page happened actually very recently on February 14, 2023. But always make sure that you have the most updated information, and the most updated information is always available from the official government sources. So, Child Status Protection Act, CSPA, it was implemented initially because the problem that was encountered with aging out. Basically, whenever the petitioner is submitting the family reunification petition, and you know, on this channel I try to concentrate more on family immigration because there's a lot of issues, there's a lot of unfair practices whenever it comes to the family immigration, and I think aging out is one of those issues. So CSPA was implemented specifically to address that issue of aging out when the petition is submitted for somebody and there is a child that is involved who is under 21, unmarried. That is the definition of the child. Unmarried, under 21 years old. And then by the time the immigrant visa becomes available, the child already, reaches the age of 21 and ages out. And now you have the situation where the child no longer can be included in the application as a derivative beneficiary, but instead you have to file a whole separate petition for your relative who now is not technically a child because they're over 21, and now you have to wait for another years and years and years in a family preference category, like for example F1 or F2B. If you look at the visa bulletin, some of these categories, they take a very, very long time. So the CSPA was implemented specifically to address this issue. So we're going to talk about a few of the categories that relying on the CSPA, basically thanks to the CSPA, now don't have to deal with the issue of aging out. So let's start from the very beginning. I'll start with the applicability, eligibility. We'll also talk about CSPA for refugees and asylees because, as you know, as a refugee or as an asylee, granted refugee and asylee, that is, you can file a family reunification petition, the form I-730, and I do have a separate video on that if you are interested. We'll talk about the immediate relative categories. We'll talk about family and employment preference, diversity visa immigrants categories. Just very briefly, we'll concentrate more on family preference categories, and I'll talk about the links and where you can get your more information on this if you want to find out. So let's talk about the applicability and eligibility. So CSPA applies only to the following people. There's immediate relatives, that is, immediate relative, your children under 21, children already means under 21, spouses of U.S. citizens, parents obviously of U.S. citizens, but CSPA in this case doesn't really apply for parents, obviously, because it's parents. Family sponsor preference principal applicants and derivative applicants. Violence Against Women Act, VAWA, self-petitioners and derivative applicants, employment-based preference derivative applicants, diversity immigrant visa, that is the DV lottery, green card lottery, derivative applicants, derivative refugees, and derivative asylees. And the derivative, if you're not familiar with the word derivative, basically if you are filing the petition, let's say for your spouse to reunify with your spouse, children of your spouse are derivative beneficiaries under 21, unmarried children. Again, the definition by the definition under USCIS Homeland Security policies, child is someone under 21 unmarried. Now, if you're filing for a green card based on one of the categories above, you're eligible for CSPA consideration if either your qualifying form I-485, which is application to register permanent resident or adjust status, or one of the following underlying forms was filed or pending on or after August 6, 2002. And of course, these are the forms that are included, that are applicable for the CSPA, which is form I, one of the first ones, I-130, petition for alien relative, I-360, that is, the special immigrant if you're filing for VAWA, I-140 if it's for alien worker, I-526 immigrant petition for alien entrepreneur, again, kind of a work-based, and then I-589, which is the application for asylum, withholding of removal, I-590, registration for classification as a refugee, and I-730, which is for refugee, asylee granted status for their relative, the petitions, which is the same as pretty much I-130, just for those people who haven't granted asylum and refugee status. So let's quickly go over asylees and refugees and the derivative beneficiaries and how CSPA applies to them. So it's really good to know, a good relief, that the age is actually frozen as of the time the petition has been submitted. So let's say you have, you've been granted asylum, and now you're petitioning for your family. Let's say you're petitioning for your spouse and your children under 21. As soon as this petition, your I-730 is accepted by USCIS, and it's the review process starts on that I-730, the age of your child is now frozen. Granted that they stay unmarried. So if by the time the petition is approved, and let's say your son you filed when they were 19, and then they reached 22, let's say, as long as they're unmarried, the age, thanks to the CSPA, is frozen as of the time the application was accepted. Okay, so you don't have to worry about any of that, except in the situations, as long as they stay unmarried. Because once they get married, that's it. They no longer fall under that definition of being a child. And it's both for refugees and asylees. The same goes for the immediate relatives. Same thing for VAWA, and then of course US citizens filing for their family reunification petitions. Same exact thing, whether you file the form I-130 or you're filing the form I-360. If the child is obviously under 21 and unmarried, by the time on the date the petition was filed and accepted by USCIS, as of that date the age of the child is frozen. Again, as long as they stay unmarried. So if you filed for your daughter, let's say when she was 18 years old or 19 years old, and the petition is approved or the immigrant visa becomes available, it's immediate relative category. So once the petition is approved, the immigrant visa is already available. But if, let's say, it takes longer and your daughter ages out, technically, thanks to the CSPA, she goes as a child, as a derivative beneficiary in the petition. Why? Because she's still considered as a child, because it's an immediate relative category. Now, it is a little bit different. It is a little bit different for CSPA for family and employment preference, and also diversity visa immigrants. That's where a little bit of issue kind of arises. I wish, that Department of Homeland Security, U.S. Congress, whoever implements these rules, they kind of implemented the same thing for family preference categories, at least where the age is frozen as of the date when the petition was accepted by USCIS. Basically, you submit the petition, they review it, everything is good, they accept it, and it's now pending with USCIS. But there is still a way for family preference categories, employment preference categories, and diversity visa immigrants to take advantage potentially of the CSPA. And here on this page right here, you can find it in case if you are dealing with a visa bulletin, then you're in one of the family preference categories like F1, F2A, F2B, F3, F4. You might be able to take advantage of the CSPA in that case, but it's going to be a little bit harder, because here you can actually, there is a formula to calculate on how much of that time you can subtract from the time the child reached the 21 years old, basically. And I will try to explain, and if you have any questions along the way, just ask me in the comments. You can ask me in this video or any of the videos on this channel, and I will try to address your question in one of the volumes where I answer your questions. So basically the formula is age at time of visa availability. Visa availability. You see, this is where the problem kind of comes into play, because now we are dealing with the visa backlog. So visa backlog, in a lot of situations, it can be 2 years, 3 years. So that time, unfortunately, does not count. The only time that counts is the pending time. And a lot of times, pending time for the I-130 is not that long with USCIS. So you take the age at the time of visa availability, you subtract the time, how long the petition was pending with USCIS, and that gives you CSPA age. And they give you an example. If you are 21 years and 4 months old, when USCIS considers an immigrant visa available to you, your petition was pending for 6 months, calculate your CSPA age as follows: 21 years and 4 months, so a little bit aged out, right? Minus the 6 months, how long the petition was pending, but that's just the I-130 petition, equals to 20 years and 10 months. So now, thanks to CSPA, not quite a lot, but still, you still fall under that 21 years old, even though you're over 21. But because you had the petition pending for 6 months, you subtract that, and now you're under 21 years old, thanks to the CSPA. So I hope you can see the problem with this right here, because again, visa bulletin, it takes quite a long time in most cases where you have to wait for the availability of the immigrant visa, and chances are your petition has not been pending for too long with USCIS. It's good if it was pending for a year and a half. That is actually beneficial in a lot of situations for you if you have derivative beneficiaries under 21, because you can use that time to subtract it from their age by the time the immigrant visa becomes available. But again, because in most cases USCIS processes these applications 6 months, year, maybe year and a half, and unlike the availability of the immigrant visa, which takes a lot longer, it still is not enough to subtract from the age when the immigrant visa is available to get down to under 21 years old. So hopefully that makes sense. Again, if you do have questions regarding this, let me know in the comments below, and I'll try to explain it a little bit better. And here they explain actually how to calculate that pending time, and the pending time is obviously your approval date minus the filing date on the receipt notice, the initial receipt notice, and that gives you the pending time of how long your petition was pending. So that is for family and employment preference categories, and also diversity visa immigrants is the same exact things. You can also do the research on if you are if you're looking into the naturalization of the petitioner in family preference cases. Briefly, basically if you are switching from, let's say, F2A or F2B, and the petitioner initially was a legal permanent resident, and while the petition was pending, they upgraded upgraded, right? They became naturalized and became a U.S. citizen. In that situation, as I always recommend, in a lot of times I recommend, switching from, because they give you an option if you want to upgrade your petition or not. And I definitely do recommend in this particular instance, because you can actually take advantage of the CSPA, unlike with the CSPA in family preference categories, where you can only subtract the pending time. Once you switch to being a naturalized U.S. citizen and your petition is upgraded, now you take a full advantage of the CSPA, where the age is now frozen as of the time the application was filed, which is obviously not much better. It's completely different on a whole different level. So hopefully this video was helpful to you. Again, if you have any questions along the way, and if you want to do your research more on this, you can find more information in volume 7 part A, chapter 7 part F, section 2 of the USCIS policy manual. Here it is. I will actually, it's really the same thing, the same information, just a little bit more an elaborate form. I'll put this link in the description as well if you want to check it out a little bit more. Hopefully the U.S. Congress, the Department of State and Department of Homeland Security, they get to changing where it is the same exact thing as it is for immediate relatives, also for family preference categories. Even more so, I think it should be the same thing for family preference categories, because again, the way the backlog is right now, the amount of time that people have to wait, it is much more likely that the child will age out, grow older than 21 years old, because because the availability of the immigrant visa takes so long. And unfortunately, you cannot subtract that wait time for the availability of the immigrant visa, because, well, it doesn't fall under the current CSPA, policy. So we will see. Hopefully that changes, but so far this is what we have, and this is what you can take advantage of. And I would obviously recommend taking advantage of that if you can. And if you have any questions along the way, you're always welcome to ask them on this channel. So hopefully this was helpful. Thank you very much for watching. As always, God bless, and I'll see you all in the next video.